I'd like to go ahead now and introduce our main speaker for this afternoon, Sarah Steins, attorney. She's a Colorado licensed attorney that practices in the areas of wills, trusts, estates, both in business and personal. She runs SJS Law, which is a growing boutique firm based in Colorado Springs with a satellite location in Parker, Colorado. She is a native with an understanding of the unique needs of Coloradans as they grow their legacy, while also having substantial international experience, which has availed her strong business and market sense. Her bio and her resume is quite robust, and I think we're going to leave it at that, and she can explain more about what her specialties are. But I think you'll be very pleased with Sarah's presentation. And just so you all know, we have senior law books here to pick up if you would like. Sarah, it's all yours.
Thank you. Okay. Well, first of all, thank you guys for having me and allowing me to come out and speak to you about estate planning. Estate planning to me is all about legacy. It's all about your desires and all about, you've worked your whole life for something. You've made meaning of your life somehow. And when you're gone, we have an opportunity through estate planning to make that last and to leave your imprint on this world. So it's a wonderful opportunity for us to talk about some tough things. Nobody likes to talk about death and dying and illness and incapacity, but we can talk about it in a way that makes it a little less scary. So I put together a PowerPoint and I told Pamela, I said, oh, I am so much better at just kind of free flowing and speaking. So I'm going to try and have my PowerPoint keep me on task. I encourage you, if you have questions, raise your hand if you're here, or put something in the chat, raise your hand on Teams, and let's have a dialogue because it's a lot more fun that way for everyone. So my agenda really was to cover an introduction of estate planning, talk to you about some do's and don'ts, and help people understand probate. I think there's a lot of misconceptions around probate, what that means. There's a lot of fear that's created around probate. A lot of it is used to market and sell other products and other things. And so I want to give you an education and maybe reduce some of that fear. So do's and don'ts. Do. I want you guys to be having conversations with the people that matter to you. You may call them family, you may call them friends, you may call them your community, but I want you to have those conversations where you can establish goals and objectives with what it means to leave a legacy. And that differs for everyone. We all have different meanings of what legacy means. Maybe it's financial, maybe it's charitable, maybe it's continuing to have a place within the community long after you're gone. That's part of that brainstorming. So I say do. And the biggest don't is don't forget to communicate. So at the root of all of this, your estate plan works best when the people in your circle know about it. That also helps reduce conflict after the fact. We'll talk a little bit about grief and what grief does to the brain. But you hear all these horror stories about my mom passed away and my siblings and I started fighting. A lot of that could be undone in advance if mom was a little more open about what her wishes were and why. So part of creating your estate plan is coming and talking to an attorney. Part of it is talking to your circle, talking to your community. The other part is there's a lot of action items that you as an individual should be taking. You should be talking to your financial institutions and asking about beneficiary designations. You should be talking to your financial advisors about, what your retirement looks like and does it die with you? So some pensions, they don't have a survivor's benefit, and that means you can't pass it on. And that may impact how you designate and how you leave other assets in your life. So have those conversations and start working with your team, whether it's your financial advisors, your bankers, your accountants, your lawyers, all of those individuals to start putting together a plan for designating those beneficiaries. And then make sure they're all working together too. So with my clients, I want to know who your accountant is. I work with your financial advisors a lot of the time so that we can all be on the same page. Again, it goes back to that communication element and knowing what the plan is so that in the event you're incapacitated and you can't speak for yourself, or in the event you've passed away, we can make sure we follow that plan and everyone kind of knows what the goals are. Monitor your circumstances. So this kind of goes into, well, how frequently do I need to have these conversations with my team? Every time there's a material change in your life, so that could be divorce, that could be a death, that could be someone moving away, buying and selling a home, buying and selling real estate in and out of the current state is a big one. Any changes in your family circumstances, so maybe new grandbabies. If your estate plan considers your grandbabies, then if there's a new one or we've got kids that are aging out, then we should be revisiting your estate plan and making sure that your legacy is still being enacted by the current documents and the current plan that you have. Don't procrastinate. I think we all procrastinate, but this is a big one. And what I want to touch on with this is kind of taking some of that pressure and that guilt away around the procrastination. I do want you to get your estate plan put together. I do want you to have powers of attorney. I do want you to have a will or a trust. But I think it's important to also understand, well, what happens if I don't have any of those documents? And I don't know how many people out there don't have those documents in place. So step one is, well, what happens if I die without a will? A lot of people think that the state gets your money, and that's just not true. But the state does get to say where those assets go. So the statute has outlined, and it's called intestacy, the rules of where someone's estate goes when a person passes away without a will. So the first thing that we do when we're in that situation is, well, did this person have a surviving spouse? If the answer is yes, we check that box because that means the spouse is going to get something. Did that person have children that survived them? And if the answer is yes, we check that box. And then we have to ask some side questions of, well, are those children of the same marriage of the spouse? Or are those children from a previous marriage? And that's going to govern how much your kids and how much your spouse get. If you have no children and no spouse, then we look uphill and we ask the question of, well, do you have parents that are still living? If you have any living parents, then your parents will inherit your estate. If you don't have parents that are living, then we start to trickle kind of outward and down. And so that's when your siblings get involved, nieces and nephews, if you have siblings that have predeceased you and you don't have parents. So it kind of follows the family tree. So that's number one, is what happens when I die without a will. If you don't want your stuff going to those individuals and you don't want it split in equal shares, or you don't want, the statute telling you what those divisions are, you need a will. And you may need a trust, and we'll talk about that too, but you need a will. What happens if you don't have powers of attorney? So a power of attorney, and we'll talk a little more in detail about it, allows someone to step into your shoes to make decisions for you when you can't make those decisions yourself. Whether that's you're not physically here, that's an option, or whether you're incapacitated. Maybe you're, in the hospital post-surgery. Maybe you have a head injury and you're not able to speak for yourself. So however long that term of incapacity is, your powers of attorney kick in. If you don't have a power of attorney designating someone to speak for you, this includes your spouse. So marriage is not an automatic opt-in for the ability to speak for your spouse. You still need a power of attorney. The only person that has the legal authority to grant someone that power is the judge. And he's down at the courthouse. And we would have to go visit him and come together and explain why we don't have powers of attorney before he would grant an order. And we call that order an order of guardianship if we're talking about medical and personal care decisions, or an order of conservatorship when we're talking about someone making financial decisions or managing your financial and legal affairs for you. Why this is important, and I think powers of attorney are the most important documents we do because they affect you while you're living, is it's so easy to avoid having to go see the judge. In our practice, it's a couple $100 to get powers of attorney done. If we have to go to court, we are talking easily $3,000 to $5,000. if we can wait 3 to 4 months. But generally, if we're going to court, it's because we need something yesterday. It's an emergency. We have bills that aren't getting paid, or someone needs to make an important medical decision. Maybe someone has had an illness and now needs to be transferred into assisted living or a nursing home. And that nursing home says, we can't take your loved one unless you have a power of attorney or a guardianship. So if it's an emergency, that cost goes up from there. And if there's any disagreement amongst your family members over who has that power, the cost goes up from there. You're talking 5 figures easy. So we can avoid all of that cost and that stress and that mayhem just by getting powers of attorney done. So my big takeaway today is do your estate planning, but if you don't want to do your will and you don't want to talk about your stuff, definitely get powers of attorney done. It's really important. So what are our different documents? We've talked a little bit about some of them. We have wills, trusts, powers of attorney. In Colorado, we have two. We have a medical and a financial. And then we have advanced directives, which are also known as living wills. So what is a will? A will is a document that simply specifies how your property, money, other assets should be distributed among your beneficiaries at your death. There's different versions of wills. So you could have a really formal one that's typed up and signed in the lawyer's office. You can also have what we call a holographic will, which is all of those handwritten wills where people, you've heard stories of people leaving an inheritance on a bar napkin or something like that. We've learned about all those cases in law school. So there's different ways that you can have a will, but the key is that if you don't have it signed in a lawyer's office in front of a notary, you need to have it in your own handwriting. It needs to be signed by you. And ideally, you should have two witnesses witness you sign it so that there's no question that you signed it yourself. Your will appoints a personal representative. Personal representative is the term we use in Colorado. It's the same meaning as the word executor. So if you've heard that, it means the same thing. Your personal representative's job is to collect all of your assets, marshal them, make sure that they are secure, pay your bills, and then make sure whatever's left gets out to your beneficiaries. And then guardianship. So if you have minor children or you have guardianship of any grandchildren, your will is a document that can say who gets guardianship in the event of your demise. Yes.
How often have you ever seen, and can it happen with the personal representative, have a child be appointed, an adult child appointed a personal representative over a spouse?
It can happen. So we go back to the priority. So again, if you don't have a will, then the statute says who your personal representative is, and your spouse will have priority over your adult children. But your will trumps all. So if for whatever reason you don't want your spouse, or your spouse maybe doesn't have capacity, maybe your spouse has dementia or some health issues and they can't serve in that role, then a will is the only way for you to choose who else gets to play in that role. Otherwise, the statute will tell us the order of priority. Good question. So we talked about a simple will. That can be just a document that says, at my death, I want my house to go to my kids. One and done. A testamentary trust will is a will that contains a trust, but that trust goes into effect at your death. And we'll talk a little bit about the different types of trusts as well. That's a situation where maybe you have a disabled child or a disabled spouse. I think that's a great example too. You can say, at my death, I want all of my assets to pour into this trust for the benefit of my disabled child or for the benefit of my disabled spouse. And you get to govern and dictate how those assets are used for that beneficiary. Who should be a personal representative? So kind of getting back to your question, you could name your spouse. If you don't have a spouse, you could look to family, you can look to friends. You want someone who is organized, probably accountant minded. So someone who's really good with numbers because they're going to have to keep track of a lot of things. They're going to have to account at the end of the day. And if you don't have a spouse or a trusted friend or family member, then there are professionals out there that do this job. And professionals run the gamut. It could be an individual who is a professional fiduciary. We have several of those in town. or it could be a bank. And I don't think Ent has a fiduciary department now, but you guys were working with investment trust services for a long time that filled that role. So talk to your bank too about who they have. I think A&B has a trust department that serves in this role. There's lots of banks here in town that fill that role. And there's pros and cons to using a bank versus an individual. Some of it has to do with cost. Some of it has to do with the type of assets you have. An individual is going to manage real estate a lot better than a bank is. Banks don't like to manage rental real estate and investment real estate. They would much rather manage your investments and your accounts. A trust. So let's talk about a trust. A trust is a document that allows you as the grantor, settlor, or trustor to transfer assets into it. You transfer those to a trustee. You as the settlor, grantor, trustor, whatever term you are using, they all mean the same thing, can serve as trustee in certain circumstances, depending on the kind of trust. And it's for the benefit of a third party. This is all a social construct. So I say that because I get people coming in all the time. And they're like, what is a trust? Is it like a real thing? Is it something we can touch and feel? Besides the contract that I give you, that's probably about this thick, it's not. It is an idea and it is a contract that is enforceable. So I think that's important for people to know too, is that we are creating something that is the function of law, and it is enforceable by the judge down the street, same one I was talking about before. But it is not a house. It's not tangible. You can't touch and feel it. And that can be really confusing for people because it's very abstract. Not everyone needs a trust. I know there's a lot of people that in town that would run around and say everyone needs a trust. Everyone should be able to avoid probate and all of those things. And I will tell you why I disagree with that. For the same reasons that I said that it's very abstract and difficult to understand, those people don't need a trust. Because it is a legal document, it comes with legal responsibilities and legal consequences, and people can get in trouble if they don't quite understand their trust document. They struggle with the abstract, and they don't understand what their fiduciary duties and obligations are. Some people do need trust, though. So types of trust. A revocable trust. This is a trust that you can create during your lifetime, that during your lifetime you can revoke, you can amend, you can change it all you want. You can put property in, take property out. An irrevocable trust is a trust that you create during your lifetime that, and I'm hedging on that. An irrevocable trust is a trust that is created. Once it's created, you can't revoke it. It can be created after death, and it can be created during your lifetime. Irrevocable trusts are often used for asset protection, meaning we want to keep our creditors away from them. Medicaid planning, tax planning. So if you are a high net worth client that is subject to estate tax limits, which right now are over $13 million per person, and not a lot of people are in that bracket, then you would maybe want to look at an irrevocable trust to transfer your assets to save on estate tax down the line after your death. We have a living trust, and we talked a little bit about that under the context of a revocable trust. It's just a trust you create during your life. The testamentary trust, we talked about that before. It's a trust that's created in your will and comes into effect at your death. And then a charitable trust. A charitable trust is a wonderful vehicle for those that are charitably minded, that want to continue to give long after they're gone to specific organizations. Do you need a trust? So let's talk a little bit more about this. In my practice, I run through a checklist in my head of who needs a trust. If you have real estate in multiple jurisdictions, meaning you've got a house here in Colorado and you've got one in Florida, you need a trust. And if you don't have a trust, then you need an LLC. And we can use LLCs and trusts to plan very similarly. So a lot of people that are working with their financial advisors or investment brokers will hear a lot about using LLCs as investment vehicles. We can kind of do the same thing with trusts or with LLCs, and there's pros and cons to both of those. If you have minor children or dependents, you need a trust. Whether that trust goes into effect today or is a testamentary trust, that's kind of to be seen. Charitable giving It's a great vehicle for charitable giving, for long-term charitable giving. So if you have that habit, if you're a business owner, having a trust can be a wonderful way to allow the business to continue after your death and for you to create confines on how that business transitions to the next generation. Blended families absolutely need a trust. We talked about the estate tax limits, really high net worth clients. Right now, it's, as I mentioned, it's about $13 million. It's a little bit over for the estate tax limit. We expect by the end of 2025, if Congress does nothing, which seems the most likely right now because Congress can't agree on anything most of the time, then the $13 million estate tax limit is going to sunset. It will roll back to the previous limits, which was $5 million plus cost of living. Spouses get to share, so that $5 million number turns into $10 million. And realistically, it'll probably be 7, I think, with cost of living, but who knows what inflation's going to do. So that's if they do nothing. If Congress acts, and I think this election's going to be a biggie, that number could change. It could stay where it's at. It could also go back down. So we just don't know what we don't know right now. If you have an asset that you want to control from the grave, and the example I have is there's, a beet farmer who inherited the beet farm from his parents and his grandparents, and they have always farmed beets on this farm. And at his death, he wants to pass the farm on to his children, but he wants to ensure that only beets, no corn, no wheat, just beets are farmed on this property. Then the way that that person can control that asset from the grave is with a trust. Any questions? Otherwise, you might not need a trust. And I think some of it comes down to that personality stuff. Oh, Charles, go ahead and unmute yourself.
Yeah, I wanted to inquire about jurisdiction. For an example, if you have a trust and it was created in the state of Colorado and you had property in another state, for an example, like Florida or Louisiana, uh, upon the time that it's required to be executed, what state would have jurisdiction over that trust in terms of execution? Will it be where it was created, or will it be where you have the most assets?
Yeah, good question. So if it's a Colorado trust, we will look to the language of that trust document that, again, governs, this social construct, this legal abstract idea that we've created and called a trust. And the terms of that document are going to tell you what governs. Generally speaking, if the trustee and the decedent were residents of Colorado and it's a Colorado trust, then the laws of Colorado are going to govern. But a lot of good trust documents will allow you to switch the jurisdiction based on where the trustee is located or where those assets are located. So the trustee often gets to choose which jurisdiction binds. You did raise a good point, though. What I want to reinforce for people that already do have trusts maybe in place, if you have real estate in those multiple jurisdictions, the only way the trust works is if those assets are titled to the trust. So if you have a house in Colorado and you have a house in Florida and you have a Colorado trust, you need to be working today to transfer title, to change the deed to name your trust as the owner of those residences. The reason that we say if you own real estate in multiple jurisdictions, you need a trust is because the rules around probate say that wherever you own real estate in your individual name at your death, you have to open probate. And probate in Colorado, and we'll talk about it, is really not that bad. But probate in other jurisdictions is horrible and it's expensive. And, if we can save those costs by making sure that your trust is properly funded now during your life, then we're really leveraging the benefit of having a trust and using that vehicle. So the big difference between a will and a trust, everyone's probably heard the phrasing in the statement that if you want to avoid probate, you need a trust. And that is a misnomer. You can have assets avoid the probate process, but generally speaking, at the death of the second spouse, and this is important, we can't avoid probate. And there's a couple of reasons why. One is for creditors. Probate is the best way to limit the reach of creditors and shorten the time period that they have to come forward. And the second is taxes, right? The only things certain in life are death and taxes. Well, the IRS says that for someone else to sign your final tax return, they need to be a personal representative. And the IRS says that that requires most people to go through probate. So that's the kicker there. Sometimes spouses, and that's, when you file a joint return, your accountant will let you sign for your spouse. That's not the case if there's no spouse there to sign for you. So the biggest difference are the assets that are governed by your will, which are only assets that are in your own name at your date of death that have no beneficiary designation. So there's no joint tenancy, there's no beneficiaries on it. That asset, if you don't have a trust, and it's not funded to your trust, is subject to your last will and testament. And those assets have to go through a process before they can be distributed. Those assets, you don't have to do anything with them before you die. With a trust, the only way that we can have those assets avoid probate is by funding them to your trust. So it requires action and some work on your behalf to get things titled to or change beneficiary designations to your trust during your life. And the assets themselves generally avoid probate. There are some exceptions. So we can't avoid paying our bills. Wish we could. But if you have a living trust, the courts have said we can't use that trust to shelter assets from your creditors that were created during your life. So those assets may have to be there to pay your bills. But otherwise, if your trust says at my death, all of these assets, all of the income and principal goes to my daughter Sally at my death, as long as those bills are paid, there's no delay in getting those assets to your daughter Sally. But with probate, we have to go through a process before we can make distributions.
Excuse me.
Oh,
can you hear me?
yes.
Can you speak a little more about blended families and how these two vehicles impact them?
Yes. So blended families need a trust. That is a catch-all. I don't think I've ever had a situation where I've said you don't need a trust as a blended family. A trust is the only way for two people to enter into an agreement as to what happens to their joint assets in the event of the death of one of them. So, for example, if you have a will, husband has a will and wife has a will, and they both agree that they want to make sure that their joint estate is split amongst their joint 6 children. Let's say they each have 3 from a previous marriage. There is nothing stopping that surviving spouse from changing their will after you've died. But with a trust, because it's a contract and it's legally binding and it's enforceable, both husband and wife can enter into an agreement that says, during our joint lives, we can do whatever we want as long as we both agree. Take stuff in, take stuff out, whatever the case may be. At the death of the first spouse, all of those assets will be there to provide for the surviving spouse during their life. And at the death of the second spouse, we both agree, and it cannot be changed, that those assets will be split evenly amongst our 6 children. So that's the blended family scenario and why I say blended families need a trust. It's just the only way that we can protect the children on both sides. It's also, I think, if you're not a blended family, but you've got concerns about remarriage, then same consideration that you probably need a trust. And then I see someone up here, I think Sue is saying, can you speak to single people? So Sue, every time I am talking about married couples, know that when I'm talking about the final iteration of, a will and your personal representative distributes all of the assets, I'm talking to you. It's just that with a married couple, we're able to kind of delay the inevitable a little bit. I always tell my clients that when they come in as a married couple, we're planning for the second spouse to die. But in your case, if you're a single person, it's even more important that we get your plan down and we have a personal representative in place or a trustee, depending on, are you a trust candidate? that knows what you're planning and is willing to enact those things for you.
And sir, before we move forward, Charles, I just want to make sure, did you have a question? And I see Aubrey, you came off mute as well.
No, she did an extremely great job in answering my question, so I'm fine. Thank you.
Okay.
I did have a follow up to the
Yeah.
blended family. What if there's property involved, and does the does and the property may belong to may be the property of only one spouse?
Yeah. And so you get the opportunity when you create a trust to carve that out with your spouse. So the, normal, quote unquote, what most people do is pour all their assets into the trust. But we can carve property out as separate property. And we can agree that maybe husband's house goes to husband's kids at the death of the second spouse. So those are all things we can do within a trust. We can be really creative, but we have to have those conversations and kind of understand what the goals are.
Thank you.
You're welcome. Okay, so I am going to skip this because I have another slide that sort of addresses it too. So understanding probate. What happens when someone dies? And I hope this gets to you a little bit, Sue. So if you die with a will and you have assets that are governed by that will, the first thing we do is we take that will to the courthouse. We lodge it with the court. Your personal representative needs to get in contact with a lawyer. You can DIY probate. It is possible. All the forms are online. DIY meaning do it yourself. You can do it yourself, but the forms are really confusing. They're confusing for us as practitioners. We have a joke that whoever the forms committee is up at the Capitol in Denver clearly never takes any of those forms out onto the street and says, hey, does this make sense to you? Because it just doesn't. So you want to get in touch with a lawyer or work through the application process yourself. Probate does not require you to see a judge. So if there's no questions about what the will says, who the personal representative is, it's all a paperwork transaction. So you'd fill out your application. The court clerks would take a look at the will and say, yep, Susan passed away and Susan said Bonnie is her personal representative. Bonnie signed this application saying she's the personal representative. There's no missing pages. It doesn't look like there's any funny business. And they would stamp an order, ordering and appointing a personal representative for probate. And then your personal representative would get what we call letters testamentary. I call that your hunting license when you are doing probate. It is the document that you take with you everywhere that allows the personal representative to step into the decedent's shoes. So can go to the bank, can talk to the IRS, can open bank accounts, can sell things, do all the things. Then the job of the personal representative is to inventory all of the assets. They have 90 days to do that. And then they have to figure out how they're going to pay bills. Now, the bill payment thing. If you die and you do not have probate open for you, your creditors have 12 months to come forward to get paid. If you open probate, we can shorten that time frame up to 4 months. So you got 90 days to do an inventory. You got 4 months for creditors to come forward. And then after your bills are paid, your personal representative can distribute the assets. Sometimes probate takes longer. And what really makes a muck of this, like it always does, is taxes. I can't control when anyone passes away, but all of us have a tax return due on April 15th. So if you pass away in February and you have a tax return due, you've generated income, or maybe there's some reason you have a tax return due, we can't file that tax return for almost 12 months. So that can keep your estate open. If you pass away in November or December, then we can file your tax return next month. So that can alter how long probate takes. Generally speaking, I tell clients 12 to 18 months for probate from start to finish. Realities of probate. You need someone to pay your taxes. You need someone to pay your bills. And the last one is probate is often the best way or easiest way to capture any assets that are solely in your name at date of death that didn't get funded to your trust or don't have a beneficiary designation. So speaking of taxes, your tax refund will often come back in your name, and sometimes banks won't let you deposit that check unless you have an estate account open. And the only way you can open an estate account is if you have those letters testamentary. Disadvantages of probate. So cost-wise here in Colorado, I don't think it's that expensive. Its court costs are about $221. If you need to see a judge for that, that's included. So those are pretty reasonable court costs. Legal fees, I would say we get probate estates in and out of our firm for $3,000 to $5,000 over the 12 to 18 months, if there's no questions or no conflicts. So that's not terrible. That's about what it costs to set up a trust. So it's kind of one of those things, you can pay it on the front end or pay it on the back end. But there are some disadvantages. Those assets are tied up in a legal process. So I can't deed the house to the beneficiaries until I know there's enough money in the estate to pay creditors. And I don't know when all the creditors are, done coming forward, other than that 4-month deadline that we talked about. Your will is part of the public record. So that is a disadvantage. It's less confidential. It will be filed with the court. It is not a sealed record, so someone could go to the courthouse and look up those records. And then disadvantage number 3 we talked about is it can take a long time. 12 to 18 months is a long time. So what are some alternative strategies that aren't a will and aren't a trust? Believe it or not. Yep, go ahead.
Real quick here. You made the statement that for probate purposes, you need an estate account. What were you referring to?
Yes, that's a great question. So when you open up a probate, when you go to the court and file the paperwork to probate a will, you are opening an estate. Those are the terms that we use. So a probate estate account is an account that would be opened up at a bank like Ent, for example. That would be where you would deposit all of the decedent's assets that are coming through the probate process.
Got it. Thank you.
You're welcome. So there are some options where we can leave the bulk of our estates to individuals without a will or without a trust. And we just have to be really mindful and creative. Beneficiary designations. If you have bank accounts, you can leave those bank accounts to a beneficiary. That includes investment accounts, retirement, IRAs, life insurance, the whole shebang. We also can use a beneficiary designation to leave our home to a beneficiary. We call that a beneficiary deed. And now we also have a document through the DMV that allows us to leave a beneficiary on our vehicles. So we can leave a lot of our stuff to beneficiaries without needing a will. The will only governs assets that are solely in your name at date of death that do not have a beneficiary designation. So if you have your assets listed by way of a beneficiary, then it's going to pass first before the will governs, essentially. And then strategy 3 is using joint tenancy, if it makes sense for you. So married couples, I generally advise my clients that if they're not using a trust, that the best way we can plan for the second spouse to pass is by using joint tenancy designation. So making sure the house is in joint, making sure the vehicles are in joint, making sure those bank accounts are in joint. And if they're not, then they need a beneficiary designation. So we can do a lot of lifting with our estate plan by going through each of those assets. And that's part of the consult at our law firm, as we walk through those assets and we ask, who's the beneficiary? Who's the backup beneficiary? And we try and plug that in so it's really effective and efficient for you. All right, let's talk about powers of attorney. So talked a little bit about them. Powers of attorney are a legal document that allows someone to step into your shoes to make decisions for you in the event you're not able to make it yourself. This is incapacity planning. So a power of attorney is in effect during your life. It terminates at your death, and then your will or your trust kicks in. So that's something to be very mindful of, is you can't use a power of attorney after death. We can use powers of attorney to allow a child to come in and help us write checks and pay bills. A power of attorney is a great vehicle for that. And you don't have to be incapacitated for them to do that. We can write that power of attorney in such a way that it is in effect today and allows them to sign for you. I think that's important because a lot of people come into my office and they say, I put my daughter on my bank account so that she can help me pay bills. And that is a really risky thing to do because now that bank account is subject to your daughter's creditors. And even if she's really good at paying her bills, we cannot predict a car accident. We can't predict anything like, an accident that she caused that spends through those insurance limits. Most of us don't have enough insurance on our vehicles. That's my biggest fear. And then those creditors will start scouring her accounts and find yours and be able to garnish wages out of your bank account. But we can, again, she doesn't need to be on that bank account. Let's just get a power of attorney in place that allows her to go to the bank and write those checks for you. Medical powers of attorney allow someone to step into your shoes to make medical treatment and placement decisions for you. So that could be long-term care placement, hospice care decisions, end-of-life decision-making. It could be surgical treatment, all that. Who should you name as your power of attorney? So your financial power of attorney, often same person you're going to name as personal representative. That makes a lot of sense to me. You want someone who is really responsible, great at paying their bills, really good with numbers, can file your tax return for you, isn't afraid or overwhelmed by adult responsibility. Now, who you want for your medical power of attorney is someone who can honor your wishes and care for you. Those people may not be the same person, and that's okay. And I tell clients that all the time. None of these roles are an honor. And I hear this from clients all the time of, oh, I just feel really bad that I'm leaving my daughter out. I don't want to hurt her feelings. No, you are doing her a favor by leaving her out because this is a job and it has a lot of responsibility and a lot of pressure. And anyone who's had to care for their aging parents before knows it is hard work. And the same thing with managing someone else's finances or taking care of an estate after the fact, especially for your kids. There is no rule book, which I think a lot of people here probably know, for losing a parent. And it affects all of us very differently. And when we are asking someone to be a personal representative in the face of grief, that's a lot. So I tell clients this all the time, that it is not an honor to be named personal representative. It is a pain and it is a big job. So when you are choosing who your agents are, I want you to be mindful of that. All right, living wills and advance directives. A living will and advance directive, same thing. When you go to the hospital, almost every time you check in for a procedure, they ask if you have a living will. A living will governs two limited situations. The first is you're diagnosed with a persistent vegetative state. That means you are comatose with brain death as certified by 2 doctors. And we ask the question, do you want to receive life-sustaining procedures? If yes, for how long? Do you want to receive artificial nutrition and hydration? If yes, for how long? The second situation is a terminal condition. So you are diagnosed with a terminal condition. You are unable to receive or evaluate information. So you can't speak for yourself, whatever that means. You could be unconscious. You could, not be incapacitated, just be not functioning. And the second part of that is not only is it terminal, but there's no treatment left that's going to extend your life. The only thing that we have is really to create comfort for you. And the questions there are the same. Do you want to receive life-sustaining procedures? If so, for how long? Do you want to receive artificial nutrition and hydration? If so, for how long? The advance directive and living will only covers those 2 situations. Your medical power of attorney covers all the rest. So think about what that looks like. Car accident, emergency room situation, fall at home. Your medical power of attorney is responsible for making those decisions for you. We can draft living wills so that your medical power of attorney can override your wishes, or we can make them binding so that your medical power of attorney must follow your wishes. And that's a conversation we have during your consult. Organ donations. I left this in here. My law clerk has a dark sense of humor, so this is just to honor Pat. But we asked the question of, are you an organ donor? Do you want to be? And the real question that we're getting at is, do you want your medical power of attorney to be able to donate your organs on your behalf? And if so, we need to know about it. You should designate it on your license, in your medical power of attorney, and in your living will. Okay, I wanted to talk briefly about long-term care planning and Medicaid planning. A lot of estate planning, especially as we get older, we have this question of like, do we have enough to cover our care? And that's what we're talking about with long-term care. Long-term care means assisted living, nursing home care, that sort of thing. So the first question that we ask here is, do you have long-term care insurance? And there is an age window that it makes sense to get long-term care insurance. And that's usually, I tell clients, start checking at about 55. 55 to 65 is usually that window. Anything above 65, usually the premiums are too high and it's just, you're precluded. If you don't have long-term care insurance and you don't have enough assets to self-insure, and what I mean by self-insure is, do you have enough assets to cover your care? And that could be cost of care in home if you want to remain in home or in a facility. And I'm going to give you some pretty startling numbers on that. So the average cost in a facility for assisted living or nursing home care right now that's not Medicaid is $10,000 to $12,000 a month. If you would like to stay in your home and you need 24/7 care, you are looking at $24,000 to $26,000 a month to stay home. Now, when I started this job, it was the opposite. It was actually much less expensive to stay home and find caregivers to come in, but that's just not the case anymore. So if you don't have enough resources to fund that and you don't have insurance, what do we do? And that's where Medicaid comes in. So Medicaid is available to an indigent population for health insurance, but that's not what we're talking about. We are talking about strictly coverage for long-term care. So you need to be placed in an assisted living or a nursing home, and you don't have the resources to pay for it. So Medicaid planning says we have to spend down your assets with the exception of a couple items. Your home, as long as we think you can go back to it, is exempt. A vehicle, especially if it can be used to take you to a doctor's appointment, is exempt. And then you're allowed $2,500 worth of liquid assets. You cannot have more than that in your bank account every month. That will qualify you for Medicaid, and Medicaid opens doors into beds, into skilled care facilities, nursing homes, and some assisted living facilities as well. So when we do an estate plan, we're really looking into how can we structure this? Do you have enough? And what are we really planning for? I think this goes into the legacy question of, I have clients all the time that come in and say, you know, our goal is to have nothing left when we go because we want to spend it all while we're here, going on lots of cruises, having a great time. And then I have other clients that come in and they are saying the exact opposite of, a legacy to me is so that my kids can really make different choices in their career than I was able to, and that sort of thing. But this pans into it too. Do you have a care plan in place? What does that look like for you? Do you have kids that are ready, willing, and able to care for you if you need it? And how long can they care for you? Any questions? I know that's a doozy. And to kind of circle back, don't forget to communicate. You need to tell your loved ones what your plans are. They need to understand why you're doing what you're doing. So this often comes up when I have families that aren't leaving equal shares to their beneficiaries, and maybe they're leaving more to one kid or another, and then they don't tell them why. And then in the light of death, it comes out that mom, cut me out. And that's really hard to hear from a stranger like me that's just trying to explain the will, or a personal representative, or your other sibling. So I want you guys to be really clear on what you want to do and why you want to do it, and make sure you're communicating. Make sure you talk to your medical team, your care team, and your healthcare team. They need to know who your powers of attorney are, what your wishes are, what your end of life decisions are. And then make sure that, you talk to your other beneficiaries as well. I've been very family focused, but I know that, charities are often named and friends are often named, and families all look different. So what we may traditionally view as biological family may not be your beneficiary, and same thing. If you have a caregiver or someone in your world that has taken care of you for a long time and you want to leave your estate to them, then they need to understand why you're doing it. And you also really need to plan in the right way to protect that gift, because those are the gifts that are in jeopardy of being overturned by an angry family member. Any questions? I have 5 minutes. Is there anything else you'd like me to speak on? Anything you want me to elaborate on? Go ahead, Jim. Jim and Sharon. You can unmute yourself. Jared, can you unmute them? No.
Yeah, I got it.
Oh, there we go.
Yeah, thanks. Really good talk. Appreciate it.
Yeah.
So we've got our will in place. We've got powers of attorney. And the lawyer that set it up with us said, probate in Colorado is so easy, you can get it done in 10 days. And it sounds like that may not be the case. So can you tell?
Yeah, you can get it open maybe in 10 days. And I say maybe because a few years ago that was true. We would be able to file an application for probate, and within 7 days, we'd have letters in an order. Now, sometimes it can be weeks. So, one of the things to know about this community is that we have 1.5 full-time magistrates hearing probate cases, and we have a judge. So a judge is just a kind of a superior person, a superior judgment maker, that hears probate cases 1 week a month. We're calling it the silver tsunami coming up, where, we have this aging population here in El Paso County. Our dockets are so backlogged. So if I right now want to get into court and just see a judge for an hour on a matter, it's often taking me 2 to 3 months to be able to find that hour in their schedule. So even though we don't have to see a judge for probate, as long as there's no questions, their staff is just overwhelmed, and it's taking weeks to get orders out. So I would say that probate is easy compared to other jurisdictions, but it's still a long process. You're not going to get around the 90-day requirement. You're not going to be able to shorten the creditor period up beyond that 4 months. And we can't close probate any earlier than 6 months after date of appointment. That's what the statute says. Any other questions? Oh, we've got a chat question. Can you read that?
I'll do it so people can hear me. So Scott had a question, or he had a scenario. So a parent has a car, 2 bank accounts containing $1,000, 2 credit cards with no balance, personal home contents, no real estate, no life insurance. So probate will still be $3,000 to $5,000? Question mark, question mark, question mark.
No, this probate will not be. So there is an exception for small estates. And I think the small estate limit right now is $80,000. So if you have $80,000 or less of assets at your death, then you can fill out an affidavit and use that to collect those assets. Now, there's a question mark about the final tax return. If you have income that requires a final tax return, you still may have to open probate formally to get the letters. And my face looks like this because every CPA kind of does things differently. They are e-filing those returns. Whether they will allow someone to sign without letters testamentary is just a gamble. It's kind of a roll of the dice. The IRS is saying, though, that whenever there's an estate or someone passes away and someone else signs a tax return, you're technically supposed to send them a copy of the letters testamentary and fill out a Form 56. And again, the only way we can get those letters is through the probate process. And the problem with the probate process is, like I said, it takes time. So for the 3,000 to 5,000, where does that come from? A lot of it's accounting. So if your personal representative is really efficient at accounting and there's no money in and out, then we don't have to spend hours in my office preparing those forms. But if it's an estate that has more assets and there's a lot of things that were sold and a lot of bills that were paid and there's a lot of in and out, we have to go through and recall those pesky forms that the government put out for us to fill out for probate. We have to take your check register and put them into the court forms, which are not at all intuitive. And we have to be able to explain every transaction, and they have monitors over there that review those accountings. I hope that answered your question, Scott.
And then I think Audrey has come off mute, so I think she's ready to ask a question.
Yes. It's more of a hypothetical, but not.
Yeah.
If in this hypothetical, you have a elderly person who owns a home, who is then put into a nursing home,
Okay.
and her family changes the deed to her home to reflect their beneficiary status. She has a trust, but now that the deed is in the family's name, it cannot be. Can it be transferred?
Well, so I would argue that the family, if she directed them to make that transfer, then that may be a valid use of that power of attorney. If she did not, then that's fraud. And we could undo that transaction. We'd have to go see the court and go talk to the judge and tell them what the family did and say that the house was supposed to go into the trust and get it fixed. But that's how we'd have to get it fixed. Or the family would have to voluntarily sign another deed transferring it to the trust. But this is why this is why during your life, when we fund our trusts, like during your life, while you are still able, this is the best time for you to transfer those assets into your trust correctly.
Thank you.
And then from the chat, so Scott said, yes, that was a great answer. Thank you. Sue had a question. She banks at End. All the accounts have the son as the beneficiary. If he goes to the bank, does he need to show power of attorney, or should I fill out a form ahead of time?
So if he goes to the bank while you are alive and he wants to write checks on that account for your benefit, that's the key with powers of attorney. Have to be used for your benefit. Otherwise, people get in trouble. So if he wants to go and help you pay your bills while you're living, he would need a power of attorney. If after death, he's the named beneficiary, all he has to do is show up with a death certificate, and then we'll do the rest with the paperwork.
And then we got another question in the chat. This one from Mel. Is that so? I'll read it, and I don't know if they can see the slideshow or not. But the question is questions. What is her contact information? And that I hear she offered a free consult.
Yes, and my information is up on the screen, so I don't know if you can see the slides. Are we going to have copies of the slideshow on the website?
So
yes,
we will.
they're already there.
Okay, so you're welcome to contact me based off of that. And yes, we do free consults at my office. I think that this is a really like a relationship-based thing, and I always want to make sure that our personalities match. And I don't think that I can do that if I don't actually sit down and talk to you and get to know you and hear what your needs are. And if I can't help you and it's not a fit, we have great colleagues here in town that we can refer you to. Anything else?
Yeah, this is Jim. Do you have where can I get the resources of what forms we would need for the probate to fill out so I could get a look at them beforehand?
Yes. So Google, it's the self-help on Colorado courts. So it's on the Colorado courts website. They have a self-help tab, and they have kind of tabs up there for different things. And it would be opening a probate. And that should take you to all the forms. The forms are, we call them JDF forms. They all start with JDF. And there's instructions on there that tell you all the forms that you need and the order of go.
Thank you.
Yeah, thank you very much.
Of course. All right.
So Sarah, we are caught up in the chat. I don't see anyone's hands raised online or anyone coming off on mute. I'm stalling a little bit in case anyone else jumps in, but I think you covered it.
Sounds good. Well, thank you guys so much for having me, and I hope you have a wonderful rest of your evening.